If a court has given you a contact order and the other parent is using their mother's house as a staging ground for breaching it, I need you to understand something before you do anything else. The document trail is everything, not the relationship, not the history, not what you know to be true. The document trail. I am telling you this from the far side of a process that took 23 months, cost me £14,600 in legal fees, and ended with a judge saying something about a grandmother that I have been thinking about in a cold and specific way ever since. I want to tell you what the judge said, but first I need to tell you what those 23 months cost me in the currency that does not appear in legal fee schedules. My name is Stuart. I am 38 years old. My daughter's name is Grace. She's 9 years old, and she has, for most of her life, been a presence so constant and so particular that I have difficulty describing her without using the word light, which I am aware is a cliche, and which is also, in this case, simply accurate. She is quick and funny and has the specific quality of children who pay attention to the things adults say when they think children are not listening. For 2 years, I saw her for what the contact order permitted on paper, and a fraction of that in practice, and the fraction changed me in ways I am still assessing. Her mother's name is Diane. We were together for 5 years and separated when Grace was 4. The separation was not, in the initial period, hostile. We established a child arrangements order through the court. Grace to live primarily with Diane, contact with me every other weekend, Friday to Sunday and one Wednesday evening per fortnight. The order was clear. It was signed. It was, as orders are, legally binding. Then Diane's mother entered the arrangement. Her name is Barbara. She is 64 years old, retired, and lives in a semi-detached house 11 minutes from Diane's flat, with a spare bedroom she had repurposed by the time I understood what was happening into something that functioned as an alternative base of operations for managing my contact with Grace. Barbara had opinions about me that predated the separation and that had been refined in the period following it into a fixed and comprehensive position. She believed, as far as I could determine from the various communications that passed through my solicitor, that I was an inadequate father, an unreliable person, and someone whose court-ordered time with his daughter was a threat to Grace's well-being that required active management. Active management is what I am calling it. What it looked like in practice was this. The first breach was in month 3 of the order. My Friday collection was arranged for 5:30 at Diane's flat. At 5:20, I received a text stating that Grace was at Barbara's and that I should collect from there instead. I collected from there. Barbara did not come to the door. Diane answered, which meant Diane was also at Barbara's, which meant the change of address had been a choice rather than a circumstance. I noted it. I did not yet understand its significance. In month 4, the Wednesday evening contact did not happen. Diane texted at 3 in the afternoon to say Grace had a cold. The cold resolved by Thursday morning per a subsequent message from Diane about school. I noted it. In month 5, the Friday collection was cancelled by text at 6 in the evening. Grace was at Barbara's and had, the text said, settled there and did not want to be moved. I drove to Barbara's house. Nobody answered the door. I could hear from the pavement the sound of a television and a child laughing. The laughter was Grace's. I know her laugh. I stood on the pavement for 7 minutes and then drove home. I want to stop here because I've been describing a pattern of contact breaches, and I want to name the thing that is not in the description. The thing I carried from that pavement on a Friday evening in November, in the cold, listening to my daughter laugh in a house that would not open its door to me. That specific, particular cold, the temperature of standing outside a warmth you are being kept from. I have not found adequate language for it. I have simply been carrying it. I contacted my solicitor, a man named Andrew, the following Monday. He was 51, had been practicing family law for 23 years, and had the specific quality of someone who is professionally undisturbed by situations that would disturb most people, and who converts that composure directly into strategy. He reviewed the texts, the logs, the Friday evening record. He said, this is a pattern. He said, we document it formally from this point. He said, "Every missed contact, every changed collection point, every unanswered door is now evidence." We documented. Over the following 14 months, the contact order was breached 19 times. I have the logs, 11 missed collections, 4 changed collection points without prior agreement. 3 occasions when Grace was at Barbara's house for the scheduled contact and was either not available or brought to the handover in a state of visible distress that resolved within 20 minutes of arriving at mine, as I noted and photographed through the window of my car before driving in 2 of those instances, to a contact centre that I had booked on the off chance that a neutral venue might reduce the handover difficulty. 19 breaches over 14 months. Andrew filed a formal enforcement application after the 12th breach. The enforcement application led to a hearing, which led to a CAFCASS review, which produced a report noting the contact difficulties without definitively assigning cause. The report recommended a review in 6 months. 6 months during which 4 more breaches occurred, all documented, all reported to Andrew, all added to the file. The midpoint is the month in which Diane filed a counter application, not an enforcement application against me. There was nothing to enforce. I had attended every contact I was permitted and several I was not. A variation application. Diane's solicitor argued that the contact arrangement was causing Grace distress and that a reduction in contact frequency with a transition period managed through Barbara's house would better serve Grace's welfare. The variation application cited a new CAFCASS addendum, noting that Grace had expressed in a recent interview that she found the transitions to her father's house anxiety-provoking. Grace, who had been laughing in Barbara's house on a Friday evening in November, was now characterized in a legal document as experiencing transitions to my home as anxiety-provoking. I want to give Diane her dimension here because I've promised it and because it is true. Diane is a person who loves Grace in the specific consuming way that certain parents love their children. As if the child is an extension of themselves, which makes the separation not just a practical division of time, but an existential one. Every hour Grace spent at mine was an hour Diane could not account for, could not control, could not be present in. Barbara's involvement was not, I believe, purely strategic. It was also emotional. Barbara was managing Diane's anxiety about letting go, and Diane's anxiety was real. And the solution they arrived at was the one that managed the anxiety at the expense of the order. That is not malice. That is a particular kind of love that does not know where it ends and the child begins. I understand it. I cannot accept its consequences. The hearing on the enforcement application and the variation application was listed together at a consolidated hearing before a family court judge named Victoria in a courtroom in Bristol on a Thursday in February. The courtroom smelled of warm paper and the particular institutional carpet that absorbs decades of difficult decisions. Victoria had read the CAFCASS reports, both position statements and my documentation log, all 19 breach entries, dated, time-stamped, some with photographic records. She had also read something else. Here is the delayed reveal. The thing I have been withholding, because it only makes sense in the context of everything that preceded it. Andrew had made a disclosure application targeting Barbara's communications, not Diane's, Barbara's. He had applied on the grounds that Barbara appeared to be a material participant in the contact arrangement and that her communications with Diane in the relevant periods were directly relevant to whether the breaches were coordinated. The application had taken 4 months to be granted and a further 6 weeks for the disclosure to be produced. The disclosure contained 43 text messages between Barbara and Diane, spanning the 14-month breach period. Not all of them were relevant. 11 were. The 11 messages documented a pattern of advanced planning, Barbara suggesting specific Fridays for Grace to be at her house, on collection dates, Diane agreeing, the arrangement then being presented to me on the day as a spontaneous change of circumstance. In 3 of the messages, Barbara used specific language. She said, if he doesn't collect from here, he's breaching too. She said, we just need to make the collections complicated enough that he stops pushing for them. She said in the most recent message in the disclosure, if we can get a variation that routes contact through my house, we control the handover. We control the handover. Victoria read the disclosure, all 43 messages. She read them in sequence, in silence, in a way that made the room very quiet. Then she looked at Diane's solicitor and said, I would like your client to explain the phrase we control the handover in the context of a legally binding contact order. Diane's solicitor said his client had not sent the messages and could not speak to another person's language choices. Victoria said, your client is the recipient of those messages. She agreed to the arrangements they describe. The distinction your client draws may be technical rather than substantive. Then Victoria said something that nobody in the room had anticipated. She directed her remarks not at Diane's solicitor, but at the position statement. She said that the CAF-CASS assessment of Grace's transition anxiety should be read in light of the documented pattern of handover management, and that anxiety produced by a managed and complicated transition was not equivalent to anxiety produced by the contact itself. She said, and this is the sentence I wrote down verbatim in Andrew's office afterward from his notes, she said, a child who has been taught to find a handover difficult will find the handover difficult. That is not evidence against contact. It is evidence of what has been done with the contact. What has been done with the contact? Victoria dismissed the variation application. She upheld the enforcement application. She declined to impose a committal order or fine on Diane for the breaches. This is the acquittal the heading promised you. And I want to be honest about it. She found that the breaches were established and deliberate, but that the appropriate remedy was not punitive, but structural. She ordered that all future handovers take place at a contact centre for a period of 6 months, after which the standard order arrangement would resume. She ordered that Barbara was not to be present at any handover, by name, in a court order. Barbara was specifically excluded from the handover geography. Barbara, named excluded. The first contact centre handover was in March. Grace came in wearing a yellow coat I had not seen before and carrying a book she wanted to show me. The room smelled of mild cleaning product and the specific neutrality of a space designed to hold nothing except what people bring to it. She showed me the book. It was about penguins. She had been told by a friend that penguins are the best animal, and she wanted my opinion on this claim. I said, strong argument. She said, I knew you'd say that. She was already slightly less careful than she had been at the previous handover, already slightly closer to the version of herself I recognized. The 6-month contact centre period is ongoing. 4 months in, Grace is closer still. The warmth is returning in increments, the way warmth does when the thing that was managing it has been moved out of the way. Victoria's order is in place. Andrew says the documentation we built, the 19 breach log, the 43 messages, the timestamps, will be the basis for any future enforcement if the pattern resumes. It has not resumed. The pavement outside Barbara's house, the November cold, the laughter inside. That detail from the beginning of this story. I do not stand on that pavement anymore. The handovers happen in a neutral room where nobody controls the geometry except the contact centre staff and the court order on the wall. The laughter happens at the table where Grace shows me penguin books and asks my opinion on animal rankings, and I do not need to hear it through a door that will not open. Here is what is not resolved. Barbara, she's 64 years old, and she loves Grace in the consuming way that grandmothers sometimes love grandchildren, as an extension of their own child, as a project of care that does not fully distinguish between helping and controlling. She is not in the court order as a wrongdoer. She is in it as an exclusion. Those are different things, and the difference matters. The court has moved her out of the handover. It has not addressed what she believes or what she will do with those beliefs in the years that Grace continues to spend time in her grandmother's house. I think about that. I am precise about what I think. because precision is what this story has taught me. I think what happens in Barbara's house on the weekdays that are not mine is still happening, and I cannot see it. And a court order about a handover location does not reach inside a semi-detached house on a Tuesday afternoon. What I want to ask you is this. If you had been Victoria, with the 43 messages and the 19 breaches, and a woman who loves her granddaughter in a way that has become a mechanism for controlling her father's relationship with her, what would you have done differently? What would the right remedy have been? Because I accepted Victoria's judgment. I think it was proportionate, but sometimes on the Wednesdays when Grace arrives at the contact centre and is careful in the way she is occasionally still careful, I wonder if proportionate was enough.